Thanks for the opportunity again. Honestly and arguably, I'll still stand by my point that in this particular instance and in this particular issue, I would say that the issues are not very strong as against the Chief Justice. But then there are several issues, okay, that come into play. Mm-hmm. Now, if we follow keenly her press conference, she did mention that the allegation, one of them said his case had been transferred from one judge to the other, and it was sanctioned by this particular Chief Justice. Another petitioner was also of the view that she had traveled and then involved her daughter. Mm-hmm. Now, like EDG was trying to say, there's been several petitions against former Chief Justices. But in all the instances, when the issues came up, the court itself was able to either cover up or at least rescue the Chief Justice at the time. Now, in analyzing this particular instance, like I've said, really, it shouldn't have been an issue. But that if you do the analysis properly, it comes to the fore that there are some debilitating issues or some factors that have accumulated over the period and then has resulted in this. Now, like I have rightly mentioned, transferring one case from a judge to the other is something they do all the time. Mm-hmm. Again, to some political functionaries or appointees are able to travel with some family members and so on and so forth. And I said, even that should have been the main issue. But then, looking at the amount involved, they mentioned $14,000. And then this lady spent around $4,000.
Are you not doing a marriage review of the petition?
No. They asked me the question.
But what I'm just saying is that that's exactly what
I didn't ask for the specific detail. And
maybe we can
be restricted.
Okay, then straightforward. But that said, I feel the press conference was wrongly done because there's a procedure to be followed. And then you go past the procedure and you come out with your side of the issue. So technically, you are telling the public and the entire world that this is your version. And if the committee comes to say anything contrary to yours, then it means there's an injustice somewhere. In siding with my brother, mm-hmm. He mentioned that
Martin.
Yes, Martin. Mm-hmm. He mentioned that at least they should have afforded her the opportunity to defend herself. Going by the 1992 Constitution, that's Article 19. It talks about fair trial. It gives some conditionalities and some provisions where one can follow. That is if you want to go about fair trial. Now, in that provision, we have the aspect that the respondent or whoever is being accused be given adequate, resources to enable the person to defend herself. Mm-hmm. Maybe in her case, she feels that the particulars or the charges should have been given her to enable her. These are some of the challenges and the loopholes that the Constitution is frowns upon. Mm-hmm. But that said, I am of the view that this has also some governance and political underpinnings. This governance and political underpinnings are things that you cannot go again. And it's not only in Ghana. Everywhere in the world, things of this nature come up. Particularly so when you have transition or new governments. Mm-hmm. I'll take you back as far back as in 1801. Mm-hmm. And the case was decided in 1803 in US of A. You know, they started this democracy stuff and so on. Mm-hmm. At the time, they didn't even know what they call judicial review. But because of this celebrated case, that's Marbury and Madison. You can Google later and then follow. In Marbury and Madison, the Supreme Court the CJ, was confronted with this challenge.
Yeah.
There is this new president in office. Then the one who lost the election had appointed some people. Some were able to be endorsed, so they could go ahead in working. But then there were some left that were not given the approval. Now there's a new president, a new government in place. And this Marbury guy wanted the court to compel, because the new government was not forthcoming. They didn't want to approve him. So he went to court challenging the posturing of the new government. And then said, Supreme Court, can you please compel this government or official to either to approve the appointment made by the previous government. Now here was a Chief Justice who was appointed by the previous president. The incoming president is also a relative somewhere. Now he was in the middle. Am I to please my my former, president who appointed me? Or I should please a family member?
Yeah.
Now he sees the occasion, whether by being biased or the family member or what.
Otherwise.
Then he said no. What I will do is that there are three issues here. Does the person have the right to come before us? Yes, I will rule in his favor that he has the right. Now, the process is seeking to ignite. Is it the right way of doing it? He said, yes, I'll prove that one. Now, the third one, the main thing that he wants me to do, that is where me too, I will depart and satisfy the government of the day. Now, the Chief Justice of Ghana is confronted with a similar situation. We have a new president. You were appointed by a previous one. But in my analysis, where I find the difficulty and why all this brouhaha, if you are unable to trace the history, we'll be doing all ourselves a serious disservice. There's a history to that. Just to the birth up of the general election in 2024, there was this serious altercation or back and forth between the Chief Justice and the Speaker of Parliament. There was an issue in Parliament that had been imported into the Supreme Court. And when it went, the Speaker or element of the then opposition party were like, this is a constitutional or procedural breach that we expected the Chief Justice to have done something about it.
What has that got to do with what's happening now? This constitutional process in place, ongoing.
That is what I'm saying.
146.
That's why I even brought in the U.S. case and so on and so forth.
I was asking about the specific reference and bearing that all of those references has on the process that is at play right now under Article 146. That
is what I'm saying. We cannot address this without bringing in some of the key factors and political underpinnings. That is why I brought in constitutionally. All I discussed were all part of constitutional review processes. Do you get my point? But in the interest of the country sometimes, it will be in favor of the Chief Justice not to fight the government of the day. There are so many ways of going about issues. Even where you feel you are at fault, you can appeal to some persons or element of the day within our government sector who, behind the scenes, can even approach the presidency or the government of the day and see how best they can go about it. In coming to 146, some of us were also against the removal of Madame Charlotte Osei and then the other... Yes, exactly. All because we felt it was the first of its kind of a nature. And more so when she was also a woman. We try to encourage women participation in our body politics. The first one has come, and now the second. If I had the opportunity, I would rather not be going on the tangent of trying to defend yourself. You get my point. Because like the antecedent I have given, there is no way an individual can challenge the powers and authority of government of the day, especially going by the provisions we have in our 1992 Constitution, where there are several loopholes, and then more so, the powers a chunk of it have been given to the president of the day or the government of the day. So where in your attempt of defending yourself or otherwise, the posturing is as if you are somewhat challenging, stemming your authority and challenging the government of the day. You rather incur the wrath, you see, of the government.
But whatever she did, that she have any specific merit or reason that you would align with that legitimizes a decision to let the public know?
Yeah, that's why I mentioned Article 19 of our 1992 Constitution. Okay, it talks about provision for fair trial. And I think it is in that light that my senior Martin Pebu was trying to see that they should have given her the opportunity, okay, to have access to some of the things. And then also the aspect that maybe in future, because this has come up, in some of the positions, we should give the victims the opportunity to decide as to whether they will have to resign as the first option. Because if you offer voluntarily to resign, then in that case, there wouldn't be the need for the state, okay, to do so many things or go through the treasurer's procedures. They cut it off and then maybe can still proceed in going into it. And if there are some further sanctions, the state can also let it be known to you. If you resign, in future, it's going to create the impression that you cannot just do things. And then when you feel it doesn't favor you, you will still be there and be defending yourself. Resignation comes with some other benefits, either to the victim or to the state as well. But she mentioned that if she did that, then it means constitutionally she was also going to lose some other benefits.
Indeed.
So now that there's no law asking her to resign, then she would rather prefer to hold on. My senior espoused some positions that it is preferable and desirable that once they have instituted the proceedings, okay, it is right for her just to stay on, so that to go through everything, and then before she can decide or otherwise. Yes, and it was not fair at this stage where they have gotten to for her to decide that this is where I want to resign. But we are of the opinion that if we have that provision also, it's going to help, because all over the world, even with our, if you recall, FIFA matters and some other big cases, okay? Apart from the CJs or Article 1 forces, there are some provisions given that whenever you are confronted with a challenge or you are going to be investigated of a sort, you have the option to decide whether you have to resign or you may want to continue with the procedure. Now, I feel when the issues come, okay, we use that as a case study to make recommendations and then also find some solutions moving forward in future. Now, if she had not done that, we wouldn't know whether in future we should allow people who have been charged of a sort to have such platforms in doing that. And thankfully, there is a constitutional review, that process ongoing, that will give the opportunity for us to decide on some of these